What's up, everybody? Jake Blickenstaff here, coming at you in another video. So I am with Jake Blickenstaff and Associates, my personal team within Virtual Properties Realty. And what I always like to try to do is come with kind of a Tip Tuesday video or something that's kind of near and dear to everybody's heart, or that is related to the real estate market that I feel that would be beneficial to be explained, or kind of a deep dive into some of the things that are going on that could affect you, especially if you're in the market to buy a house, sell a house, if you own a property already, if you're looking at another one in the future, or possibly if you're an investor and you own some rental properties. So we all know that 2020 has been absolutely crazy, and it's still carried on a little bit over to 2021, all due to COVID-19. So with that being said, paying attention to kind of what's going on in the news, it's sometimes difficult to differentiate which direction we're going to go. And I'm by no means making this political whatsoever. However, there are some new updates that came out today that do have to do with the real estate industry with regards to the eviction moratorium. So I'm going to share my screen real quick and kind of go over in detail the short version of what the moratorium new extension results are. And then afterwards, I'm going to go into kind of the deep dive of each section that the National Association of Realtors have put out that really expands kind of on each section in case you need some clarity. Now, there are going to be 4 sections towards the end of the video. It's going to be talking about the eviction moratorium in detail, the emergency rental assistance, property management issues, and then tenant issues. So if you look below this video, there's going to be a time marker for each one of those 4 sections if you want to just skip through the rest of it and go straight to that. But if anything, just stick around for this first portion, and it's going to be the quick kind of Cliff Notes version like I was talking about. All right, so this is the eviction moratorium that just came out on March 29th. And this is going to be just a 1-page kind of little expose that they have. So I'm going to read through it in detail so that way you guys understand and know kind of what's going on, or at least have a kind of broad strokes update of it. So the CDC and Prevention announced the issuance of an order under Section 361 of the Public Health Service Act to temporarily halt residential evictions to prevent the further spread of COVID-19. All of this started, if you guys remember, back in September 4th of last year. And now the extension is gone through until June 30th of 2021. So who all does this cover? All properties except vacant and abandoned. Any resident who certifies they meet the below criteria may not be evicted for failure to pay. The CDC's order requires residents to declare under penalty of perjury that they have used best efforts to obtain all government assistance for rent or housing, expect to earn no more than $99,000 individually or $198,000 jointly in 2020, or was not required to report income in 2019, or received an economic impact payment from the CARES Act, are unable to pay the full rent or housing payment due to substantial loss or household income, loss of hours, layoff, or extraordinary medical expenses, are using best efforts to make timely partial payments. Eviction would likely render them homeless or forced to move into close quarters in congregate and shared living settings due to no other housing options. Has or was exposed to or might have been exposed to COVID-19 and is taking reasonable precautions not to spread the disease. So what eviction is allowed? Landlords may still evict tenants due to criminal activity, threatening health and safety, damaging property, violating codes or ordinances, or other contractual obligations. Question is rent still due? Yes, rental payments are still due. This order does not relieve anyone of the obligation to pay rent or make a housing payment or follow other terms of the lease. In addition, landlords may charge late fees, penalties, and interest for any missed payments. However, they cannot evict any tenant until the expiration of the notice, which is now June 30th of 2021. So how is this going to be enforced? This is to be enforced jointly by federal authorities and cooperating state and local authorities. The Department of Justice may take independent action The order is enforceable through criminal penalties to individuals of up to $100,000 to $500,000 per event and 1 year in jail, and organizations of no more than $200,000 per event if the violation does not result in a death, or $500,000 per event if the violation results in the death of an evicted person from COVID-19. What else? Allows for more restrictive state and local protections, but overrides anything less restrictive. So that's the quick one-page version from the National Association of Realtors, summing up what the CDC's federal eviction moratorium looks like. So if you guys want some additional details on this and you don't want to watch the rest of the video, like I said, you can check below here and you can fast forward to those points that I mentioned. I'm also going to include links to all of these documents so that way you can reread them, print them off, whatever at your leisure. So now jumping over into the longer section, this one's going to be 9 pages long. But what it does is it breaks down each one of those 4 categories. So one category is the eviction moratorium. The other category is going to be emergency rental assistance, then property management issues, and then tenant issues. So for the eviction moratorium, what properties are covered by the federal eviction moratorium? All rental properties are covered by the CDC notice. NAR, or the National Association of Realtors, has published a 1-page summary, which I just got finished reading, of the order by the CDC. It does not apply to residential properties and locations with an eviction moratorium that provides the same or greater level of public health protection that the requirement of the order. It also does not apply to American Samoa. When did the federal eviction moratorium begin? The moratorium began on September 4th of 2020. After that date, the housing provider may not evict for failure to pay any tenant who submits a signed attestation per the notice through June 30th of 2021 per the March 29, 2021 CDC order, which is the one that I'm reading currently. This deadline has been extended from the original date of December 31st. Make this a little bit bigger for you guys. Is rent that accrues during the eviction moratorium forgiven? No. The moratorium prohibits housing providers from evicting, but does not forgive the rent that is due. In fact, the tenants who have attested and received the eviction moratorium, a property owner or agent may charge penalties, late fees, and interest per the lease. How can the government do this? Isn't this a Fifth Amendment takings? The order by the CDC is based under Section 361 of the Public Health Service Act and is designed to prevent further spread of COVID-19. Legal challenges are underway. Does a property owner have a legal obligation to notify tenants of the CDC order or their right to file attestation? The order does not place any affirmative obligation on a housing provider. So essentially that means that they're on their own to figure out what the new changes are regarding the moratorium. How and when does a tenant provide declaration? There's no time frame specified in the notice. The declaration attestation is simply provided to the landlord before the tenant has been evicted. There is no waiting period or time requirement provided by the notice. There's no form provided in the notice, but the tenant is not required to utilize that form. They can supply the declaration in any written form they prefer. Is there an appropriate way to request past due rent without having to do a 30-day notice rent to quit? An owner can certainly make a request for rent payments that are due during the eviction moratorium. Owners may also enter into repayment agreements with the tenants during the moratorium, making clear the amount due and the terms for repayment. Section H, if a tenant doesn't pay the full rent on time, can I send a late payment notice to the tenant? Yes, but with some caveats. The moratorium prohibits initiation of eviction proceedings, but it does not prohibit an owner from sending the tenant a notice that the rental payment is late or incomplete. Among other things, if an owner wants to initiate collection or eviction proceedings after the moratorium ends, it is wise to have a copy of these notices on hand, making clear that the housing provider documented the non-payment and provided information to the tenant. If you send such a notice, you should consult with legal counsel about the wording. Among other things, the notice needs to indicate that it is not itself a notice of eviction. What other steps should I take if a tenant doesn't pay full rent on time? In addition to providing notice of non-payment, many owners are asking tenants to execute a formal forbearance agreement. These documents constitute a contractual agreement between the housing provider and the tenant, identifying the amount of rent that is unpaid and providing terms for repayment in the future. If a tenant has a good rental history in the past, it may be desirable to work out terms for repayment after the moratorium, rather than go through the efforts to evict a tenant now and try to re-rent the unit. From the tenant's point of view, many are eager to enter into a forbearance agreement that establishes a mechanism to pay accrued rents to avoid having to pay all accrued but unpaid rent in a lump sum at the end of the moratorium period. A forbearance agreement classifies what the tenant owes and when it will be paid, and provides remedies that the housing provider can exercise if the repayment terms are not met. Again, housing providers need to consult with legal counsel to make sure that the forbearance agreement complies with state and local landlord-tenant laws in general. And that's all going to be different based off the state that you're in. I'm personally in Georgia, so I'll provide a link to the landlord-tenant laws for here in Georgia as well, in case you need that as a reference. Can tenants pay partial rent? Some housing providers may want to enter into a rent discount agreement with the tenants, under which the tenant agrees to pay a discounted amount of rent on the regular due date each month. Many tenants, even if they recently lost their job, will continue to receive some income from unemployment compensation and other sources, and would be willing to pay some portion of their current rent to avoid facing a lump sum at the end of the moratorium period and possibly eviction thereafter. Likewise, many housing providers would prefer to receive at least some portion of their rental income on a current basis, rather than no income at all and face the cost of uncertainty of eviction in the future. Again, any such discount agreement should be prepared by legal counsel familiar with the state and local landlord-tenant requirements. Section K, if the tenant does not pay rent during the eviction moratorium, when can I start charging fees or penalties for non-payment? You can start immediately. Unlike the previous moratorium in the CARES Act, which has currently expired, the CDC notice allows a property owner to charge late fees, penalties, interest, or any other rent that accrues during the eviction moratorium period, September 4th through June 30th of 2021, per the terms of the lease. Section I, am I allowed to initiate eviction for cause, such as criminal activity, etc., during the eviction moratorium? Yes, you may. Moratorium only applies to actions for non-payment of rent or other fees or charges. CDC notice specifically states that a tenant may be evicted for engaging in criminal activity while on the premises, threatening the health or safety of other residents, damaging or possessing an immediate significant risk of damage to the property, violating any applicable building code, health ordinance, or similar regulation relating to health and safety, or violating any other contractual obligation other than timely payment of rent. Section M, what can a landlord do if a tenant has declared that they are a covered person under the CDC order, but the landlord does not believe the tenant accurately qualifies? The order does not preclude a landlord from challenging the truthfulness of a tenant's declaration in any state or municipal court. The protection of the order applies to the tenant until the court decides the issue, as long as the order remains in effect. Section N, what if a renter's lease is up? Can a housing provider simply choose not to renew? What if the renter refuses to leave the property? Can you evict under the CDC moratorium order? The order prohibits eviction for non-payment. If a renter submits a declaration, it also must for cause evictions, such as where a violation of a contractual obligation occurs, but it is not clear whether holding over at the end of the lease term is sufficient to trigger violation of the contractual obligation. That would allow eviction. It depends on the terms of the lease, state and local laws. Many leases convert from a lease for a term to a month-to-month lease automatically if the renter holds over. If so, holding over may not technically be violation of the lease terms. Section O, is there any federal money available for rental assistance? Yes. The December COVID relief package included $25 billion for rental assistance, and the American Rescue Plan passed in March 2021 provided an additional $21.55 billion. The monies were allocated to states through the Department of Treasury. State allocations are based on population, with no state receiving less than $352 million from both funding rounds. The language allows landlords to apply the funds on behalf of tenants with tenant consent. Rental payments may include rent in arrears, as well as utilities and other expenses related to housing. More importantly, the rental payments will be made directly to the housing provider or utility providers unless the payment is refused by same. These monies are now being distributed to the states and should be available for application within the next few weeks. In addition, a number of states are already providing some limited rental assistance through previous COVID relief funds. More information can be found here. I will include this link below. State rent or mortgage relief programs. For more information on the federal rental assistance program, see number 3 below, which is going to be the property management. What does the CDC order mean by eviction? According to recently released guidance, the order is not intended to terminate or suspend the operation of any state or local court, nor is it intended to prevent landlords from starting eviction proceedings, provided that the actual eviction of a covered person for non-payment or of rent does not take place during the period of the order. This is going to be section 2 for the emergency rental assistance. So for section 2, line A, how much money is available in federal rental assistance? December 2020 COVID relief package included $25 billion for rental assistance, allocating at least $200 million per state, with more available based on population. States applied for the funds to the Treasury Department in January, which dispersed the money to each state accordingly. Each state is tasked with creating its own program within the guidelines set by the Treasury Department, which will be administered by the state housing agency. The American Rescue Plan Act, which became law in March 2021, includes an additional $21.55 billion in dedicated rental assistance funds, along with the funding for the housing vouchers. From that funding, each state will receive at least $152 million. Line B. What are the guidelines set by the Treasury Department for these states' programs? Let me bump this up one more time. The Treasury Department released upon or updated FAQS for states or grantees to use when creating their programs on February 22nd of this year, 2021. Some of the most relevant information for the housing providers are eligible households must have at least one person who qualifies for unemployment or who has experienced a reduction in household income, incurred significant costs, experienced financial hardship due to COVID-19, is at risk of homelessness or housing instability, has a household income at or below 80% of the area median income, or AMI. Applications for rental assistance may be submitted by either an eligible household or by the housing provider on behalf of an eligible household. Applicants can self-certify that they meet many of the requirements at the time of application, and income may be determined based on either the total income of the year of 2020 or the monthly income at the time of application. Assistance can be applied for 3 months at a time, not including rent arrears, totaling up to 12 months. Grantees may provide an additional 3 months assistance beyond the 12 months if they determine it is necessary for the household. Rental arrears payments are to be prioritized, though it does not require that they be fully paid before applying to prospective rent. Tenants that receive housing subsidies are eligible for rental assistance to cover any portion of the rent, utilities that the tenant pays themselves. Housing providers can accept direct payments on behalf of tenants, but must confirm their cooperation with the state program. Outreach to the housing provider to confirm this by the states will be considered complete if one of the following conditions is met. A request to the housing provider sent by mail, which the housing provider has 14 calendar days to respond from the date of original mailing. At least 3 attempts by phone, text, or email over a 10 calendar day period to the housing provider. Or the the housing provider confirms in writing that they do not wish to participate. The Treasury has stated that further guidance is forthcoming, which will provide more details on these requirements. More information can be found here for the emergency rental assistance page. Line C, how do I access federal rental assistance? Each state will have a different program provided through its housing agency. Many state programs are open to applicants and have preliminary information available. Some are finalizing theirs and have not provided information yet. The National Council of State Housing Agencies, or NCSHA, has provided information on state-by-state programs, which can be assessed here. And line D, $46.55 billion doesn't seem like enough money to cover all the rent that's owed. What happens when the money runs out? The American Rescue Plan Act, which has passed the House of Representatives, has been sent to the Senate for a vote, includes an additional $21.55 billion appropriated for emergency rental assistance, along with the additional funds for housing vouchers and other programs. Though that still is unlikely to be enough to cover all the rental arrears owed to in the country. It is important to remember that the CDC eviction moratorium does not forgive the rent that is due. Any rent owed by a tenant above, which is covered by emergency rental assistance, will still be owed when the moratorium comes to an end. And section 3, property management issues. NAR also recommends realtors visit the Institute of Real Estate Management website, and that's going to be right there for more information. The economy is reopening, so how should housing providers respond? Maybe the economy is reopening, but housing never closed. Indeed, the basic strategy from government authorities for the last 6 weeks has been to shelter in place at home. In other words, staying at home has been our national response to COVID-19. In the absence of a vaccine, reliable medical treatment, or adequate testing, contact tracing, isolation, it is likely that at least to some extent, the virus will spread more quickly as the economy reopens than it has in recent weeks. That means that it is more, not less, likely that the virus will circulate at rental properties. If so, housing providers need to maintain and, if necessary, increase the steps that have been taken to minimize the spread of COVID-19 virus at their properties, even as the rest of the economy begins to open. The governor wants to liberate the state. Do I have to liberate my property too? Many government authorities adopted rules to strictly enforce social distancing, including closing businesses. These policies gave owners and managers implied authority to adopt similar restrictions at their properties. As governments began to lift the restrictions, some residents pressed to lift restrictions imposed by housing providers. There are good reasons to keep restrictions in place. However, first, as noted above, if residents return to work and become exposed to the virus, there is more reason than ever to take steps to prevent them from exposing the virus to other residents. Also, the housing belongs to its owner, not the residents, and in most jurisdictions, owners retain broad control over the use and operation of their properties. Finally, in most jurisdictions, civil authorities themselves are lifting restrictions in phases, hoping to prevent new disease flare-ups, and housing providers are justified in using similar caution and removing their own precautions. Just because civil authorities lift restriction does not mean housing providers are required to do likewise. Whew, glad I got some water. Social distancing. What are the best practices to encourage for social distancing? I think up to this point, for social distancing, having been doing this for the last year, I think everybody's pretty familiar with this. If not, I'm going to allow you guys to Google it, and I'm going to skip to the next section. So can a landlord require masks in all common areas? Just as a restaurant can adopt a no shoes, no shirts, no service rule, landlords generally can adopt rules restricting the use of their public and common use areas, including requiring tenants and visitors to wear masks. Owners' decision to require masks in public places will be strengthened to the extent that the state and local governments have adopted rules requiring masks in public places. The rules may be slightly different for federally assisted properties, including Section 8, Section 202, Section 811 properties. According to recent HUD guidance, owners of these properties can update their housing rules to require face coverings, but must give existing renters at least 30 days notice of any such change. Persons within the initial lease term must be given 60 days notice prior to the end of their lease terms. The changes must be approved by HUD and must be within the bounds of common sense and not excessive or extreme. The FAQS stated that the rules concerning face coverings must be consistent with state and local law directives from public health officials, suggesting that approval is less likely in places that have not adopted requirements to wear face masks in public. Line E, can a landlord prohibit outside guests from a property? Common law allows landlords to prohibit trespassers on the property, but also gives tenants the right to invite guests. If a property owner wants to limit non-resident activity or access on the property, there are several steps that they can take. Landlords can require that all persons on the property, including contractors hired by the tenants, must confirm that they have no current COVID symptoms and have not traveled to any place where the virus is prevalent. If possible, there should be some sort of check-in procedure. Posted signs should also say that visitors are subject to getting their temperature taken before being admitted. Landlords may also require that all deliveries may be made to a central location rather than throughout the property. Posting signs like that will discourage a lot of unwanted people from coming in. Staff should be familiar with the requirement, and to avoid subsequent claims of discrimination by or other terms of liability should apply it uniformly. With respect to housing for older persons, the CDC has said for months that at retirement communities or independent living facilities, non-essential visitors should be limited, 1 visitor per day, and should be restricted to persons who are essential to preserving health and including mental health, well-being, and safety of residents. With respect to federal assisted housing, including Section 8, Section 202, Section 811 housing, to the extent that HUD's new FAQS require changes in house rules to implement a mask requirement on tenants, that guidance and also suggests that owners should consider changing house rules if they want to restrict visitors. These same requirements for 30 and 60 days notice referenced above and HUD approval apply. And line F. Could a landlord require temperature to be taken for any outside guests? Again, owners have latitude with respect to admitting outside persons onto their properties, which would include taking the temperature of visitors. Signs notifying visitors that they may be required to have their temperature taken should be posted at the entrance of the property, and with other precautions, staff should be familiar with the requirements and apply it uniformly. However, as with other requirements for wearing masks and restricting visitors, HUD's recent FAQS suggest that owners of Section 8, Section 202, Section 811 housing wishing to require visitors to submit to temperature testing should adopt applicable house rules, subject to the same 30 and 60-day notice and HUD approval requirements. All right, now we are down to the last section for tenant issues. We get one more drink of water and then we'll finish this out. Line A under 4. Must a landlord consider unemployment assistance as a form of income? In most cases, no. Owners are under no federal requirements when it comes to counting unemployment assistance as income in connection with lease applications. In addition, the one-time $1,200 check received by many taxpayers was a tax rebate or credit, should not be included in calculating a tenant's income. If you are in a state locally that has sources of income provisions in its discrimination laws, owners should check with legal counsel to determine how to treat unemployment compensation to avoid discrimination laws. If you participate in HUD assistance housing, the amount of assistance a family receives may be affected by the amount of income they receive, and so it is important to know how to count unemployment assistance. Housing providers are urged to be in contact with their housing authority to clarify how this is treated. B, communication with residents. What is the best policy for communication with residents? If they have not done so already, housing providers should communicate frequently with residents, providing them with regular updates about the steps that they're taking to maintain a healthy environment. Signs and posters should be placed around the property to encourage personal hygiene, wash your hands, and other steps individual tenants can make to take themselves and the property safer. Examples are available on the CDC website. If they have not already done so, housing providers should explain to residents that the COVID-19 virus is still spreading rapidly through the population and that they should assume that other people, including other residents at the property, may be carrying the virus and taking appropriate precautions. Residents should be reminded that if everyone takes precautions to protect themselves from the virus, it will improve the health prospect of all residents. So what should you do if you learn a resident or staff person has tested positive for the COVID-19 virus? First of all, do not respond to rumor or gossip. A verbal report from one of the tenants that another tenant is sick or has suspicious symptoms is not sufficiently reliable to take action. The situation is different if a housing provider receives a reliable statement from a tenant that he or she has tested positive or a similar report for a public health official. Although the law varies greatly from place to place, as a general matter, a landlord has a duty to warn tenants of known hazards at the property. While there is no case law specifically with respect to COVID-19, reliable information that someone at the property has tested positive for COVID could be deemed to constitute knowledge of a hazard that should be shared with other tenants. At a minimum, disclosing that information will encourage other tenants to redouble their efforts to avoid the virus, which will make the housing provider's job easier. But as discussed below, you should not disclose specific resident or employee names or information. Better to communicate with the issues generally and steps taken to protect themselves and the staff as to not be exposed. Both the HUD and CDC have advised that housing providers can inform residents that a staff member or another resident has tested positive for the virus. Be aware, however, that some local public health agencies have urged housing providers not to disclose this information, largely to protect the privacy interest of persons who test positive. Before notifying other residents, even generally, that someone on the property has tested positive, you should try to determine if your local public health agency has published guidance. Section 3, if I decide to disclose that someone at the property has tested positive, can I disclose who that person is? No. Medical information is subject to a variety of state and federal privacy protections, and providing personal identifying information about someone who has tested positive would likely violate these principles. And employees may also be protected under privacy and labor laws, given the widespread presence of the virus and many asymptomatic people who may be spreading the virus. Information that a particular person has the virus may not provide really useful information as a practical matter. It also may create issues for the resident or employees that will only complicate dealings with other residents. Disclosing this information would make it much less likely that the other person who tested positive would disclose that information to you. Housing providers should politely discourage any request to share personally identifying information about a person who has tested positive, explaining that they treat all residents' privacy seriously and reminding residents that if they tested positive, they would want the housing provider to treat their personal health information similarly. Line C, a resident has tested positive for COVID-19 virus. Can I ask them to vacate their unit or evict them? Except in extraordinary cases, no. HUD guidance is that in most cases, persons who have tested positive can successfully isolate themselves in the unit until they recover. If a person has tested positive for COVID-19 refuses to self-isolate, however, housing provider should consider taking additional action. Housing providers should check with legal counsel to determine whether the lease form and applicable landlord-tenant laws allows additional action against non-compliant tenants. While it does not expressly discuss grounds for eviction, the Fair Housing Act does not protect persons from discrimination who present a direct threat to the health or safety of others. Conceivably, someone who fails to comply with direction to self-isolation may prevent such a direct threat, but courts advise that each direct threat claim must be based on an individual assessment of the specific facts of each case, including whether some action less than eviction may persuade the person who has tested positive to follow self-isolation guideline or guidance. In serious cases, it may be appropriate to seek advice from local public health or law enforcement officials. Cleaning. What additional cleaning procedures should housing providers adopt? Since the beginning of the pandemic, the CDC has urged constant cleaning and disinfecting. That's been pretty clear from the beginning, if you can find any Lysol on shelves. Disinfecting contaminated apartments. Talks about the details of that. Tenant services, staffing, marketing. How should I manage on-site property management staff? The management of a multifamily housing property is a business like any other. In addition to worrying about the health and safety of their residents, housing providers need to worry about the welfare of their staff as well. At least in those jurisdictions that remain subject to stay-at-home orders, the first question an owner needs to confirm is whether on-site property managers are deemed to be essential workers. But even where on-site staff is deemed essential, most housing providers have adopted systems to minimize the number of persons required to be on site, such as using more electronic and remote services, tenant transactions, and restricting maintenance to only emergency repairs, as discussed below. How should you handle maintenance requests? Maintenance requests are a good example of the practical problems posed by the virus. Since the virus began to spread, many housing providers have announced that they would only undertake emergency maintenance and repairs. Maintenance staff, and grudgingly, most residents accepted this solution to avoid contact that could spread the virus. But exactly what constitutes an emergency varies widely, and some residents report that repairs to important fixtures, refrigerators, water heaters, ovens has not been treated as emergency matters. As the weather warms, air conditioning needs also will become urgent, and housing providers do not want their residents to undertake DIY fixes that may present fire, flood, or electrical hazards. Over time, wider availability of personal protective equipment, or PPE, for both repair crews and residents may make people more comfortable about permitting in-unit repairs to take place. If units are occupied, repair crews should plan to wear their own PPE, at a minimum masks and gloves, and bring similar PPE for occupants in the unit while repairs are being performed. To protect my staff and tenants, can I use remote and electronic services to deal with tenant transactions? Yes. Many owners have discovered that modern technology allows many transactions that were formerly performed in person to be moved online, including making rent payments and submitting maintenance requests. Because of efficiency gained, some housing providers may decide to retain these electronic systems after the crisis passes. The availability of remote electronic services, however, is not universal. Not all tenants have access to computers and tablets, and even when they do, their operating systems may not mesh with the housing provider system. Backup systems such as lock boxes to collect rent may still be needed. Also, to the extent that housing providers move services online, they need to make sure that those services are equally available to persons with visual and hearing impairments. Websites that are not accessible to persons with disabilities may result in claims of discrimination under the Americans with Disabilities Act, the FHA Act, and also other federal and state anti-discrimination laws. What should I do about apartment tours? Here again, many housing providers are turning to remote and electronic alternatives to providing pre-rental apartment tours. Video sessions on FaceTime and other apps serve most of the needs of prospective renters to see a unit and assess its conditions. While not the ideal solution for anyone, most prospective renters and housing providers are aware of the health dangers posed by physical meetings and look at video tours as an acceptable alternative under the circumstances. Here too, however, housing providers need to be aware that to the extent that they rely on electronic means to provide apartment tours, those media must be accessible to persons with visual and hearing impairments too. All right, so that pretty much breaks down everything with the eviction moratorium, the new update that just came out March 29th of 2021. So feel free to jump back. It was a lot of stuff for one, not only to read, but for two, to digest. And It's even longer if you like look at the NAR site below, where it's going to have kind of the breakdown. So those PDFs that they put together are really, really beneficial for not only me to provide you guys some value of like kind of the Cliff Notes version of what's going on, but that also prevents you from having to go out to one of the other government websites and actually read verbatim the eviction moratorium and try to decipher, if you're not a lawyer and you don't understand legal jargon, on how that's applicable to your current situation, especially if you are a landlord or maybe you're a property manager, or even a large commercial manager where you're an owner of multiple apartments with hundreds of units and things like that. So if you guys have any questions, if there's anything that you're not certain on, feel free to reach out and I'll try to do my best to provide you with an answer, or at least a good source of where you can get the answer. But once again, this is Jake Blickenstaff on our extended version of Tip Tuesday for today on the eviction moratorium. And if there's absolutely anything in the world that I can do for you guys, just make sure to let me know. My number is 404-281-5002. And make sure you like, comment, and subscribe if I'm providing you guys with some value, if there's anything specifically that you want to see. But we'll see you guys on the next one.